Are legal deadlines in calendar days or business days in the state of Oklahoma? I'm Appellate Attorney James Wirth, and that is the question that we have. And it's coming from a new case recently decided and published from the Oklahoma Court of Criminal Appeals, 2024 OKCR 15. And that deals with the timeline for a person to withdraw their plea of guilty. So essentially, this person was represented by an attorney, and they entered a plea, and they were sentenced, and then they wanted to withdraw that plea. And they were advised at the time that it was entered, because it's part of the normal paperwork, that they've got 10 days if they want to request to withdraw their plea. They've got 10 days to do so. That doesn't mean it's going to be granted. It's almost always not granted. But if you're going to do it at all, it needs to be done within 10 days. So what that person did was that he then, on the 13th day-ish, talked to an attorney and got that attorney to, the attorney that represented him, got that attorney to file a motion to withdraw the plea at that time. And the question is whether that 10-day rule is 10 business days or is it 10 calendar days? Because if it's 10 business days, he filed on the 9th day, but if it's on 10 calendar days, then it's filed on the 13th day. So it notes that petitioner testified that he believed his motion to withdraw the guilty plea was due within 10 business days. It was filed 9 business days, but 13 days after pronouncement of the judgment and sentence. So this is a pro se person who talked to get an attorney to do it at the last minute. So during that time period, he was acting on his own and didn't realize he thought it was business days. Okay, well, the court has dealt with this somewhat recently once before when this was clarified, and it has to do with the difference between civil cases and criminal cases. Because the general rule is that we're all familiar with it or work with these things is based on the Civil Code. It's Title 12, Section 2006. And it talks about when computing time for legal deadlines. It says in computing any period of time prescribed by this title, by the rules of any court of this state, or by order of a court of this state, the day of the act, event, or default from which the designated period of time begins to run shall not be included. So this says that two important parts of this. The first part is that saying that this applies to everything, every court, every rule, everything, and that it's the first day does not count. And then it goes on to prescribe other rules, and then it says when the period of time prescribed or allowed is less than 11 days, intermediate legal holidays, and any other day when the office of the court clerk does not remain open for public business until the regularly closed scheduling time shall be excluded from the computation. So it says if the deadline is 11 days or more, then we're talking calendar days. But if it is less than 11 days, then we're talking business days. Now this is in the same section that says it applies to every court of the state. However, this particular, same section, but this sentence doesn't say that. So the Oklahoma Court of Criminal Appeals, previously in a case in 2016, first addressed this issue, at least in recent times that I've seen, where they said, no, though it's 10 days, and even though the statute under the Civil Code says that you don't count closed days, and that it's business days, not calendar days, for the Oklahoma Court of Criminal Appeals, we're going to say that it is calendar days, even if it's under 11. So that's what they decided in this case 2016 OKCR1, and now this issue is before the court again, where they're alleging that a pro se litigant made this mistake, and they're saying because he's pro se, they should be more lenient on him, and because the only difference is between calendar days and legal days, and I would argue because of the ambiguity created by the Title 12, Section 2006, that says it applies to every court right here, and then talks about a rule that the Oklahoma Court of Criminal Appeals says doesn't apply to them. Nonetheless, Oklahoma Court of Criminal Appeals held firm, noted that the statute by its language says within 10 days from the date of the pronouncement of the judgment and sentence. That's a quote. It doesn't say calendar days or business days. The Oklahoma Court of Criminal Appeals rules just says days, and that's why there's a little bit of ambiguity. But it says, despite counsel's argument that we should accommodate his mistaken belief as a pro se litigant, this court has also enforced time limitations of these kind against those acting pro se. So it says it doesn't matter if you're pro se or if you're an attorney, we're going to apply the rules to you the same, and we are applying the rule this way. Then we go on, and there is a concurring opinion by Judge Lumpkin that goes further into the pro se issue. It says pro se litigants must become familiar with the rules before attempting to practice before this court. Pro se's are held to the same standard as attorneys, and with this issue, this is something that we have seen attorneys make mistakes on because it is so ingrained based on pretty much everywhere else that if it's under 11 days, you're talking business days. But with the Oklahoma Court of Criminal Appeals, no matter how many days it is, they're always talking calendar days, so don't make that mistake. Note that it is going to be calendar days if it's before the Oklahoma Court of Criminal Appeals, and it's a criminal deadline. If it is pretty much anything else, it's going to fall within the, if it's under 11 days, then it's business days. But don't take my word for that. You're going to want to talk to an attorney about your specific circumstances to see what the deadline is for you. To talk to an attorney with my office, you can go online to makelawEasy.com.